Welcome to this presentation of Tales of the Expected and the Unexpected, excuse me, and planning for later life care and the importance of a power of attorney. We're joined this evening by Gail Hall, partner at Warner's Solicitors, and Martin Terrell, partners of Warner's Solicitors. I think everyone can see you, so if you give everybody a wave. Good evening.
Good evening.
What we're hoping to do this evening is to give you a very good overview of planning for later life care, the importance of a power of attorney, and told through the tale of two case studies. What I'm going to do now is go to the next slide, please, Kerry, so that we can do some housekeeping. There we go. Just to let everybody know, you are all muted. All of our attendees are muted, and all of our attendees have their cameras turned off. We cannot see you, we cannot hear you. This webinar is being recorded. We will be sending it out to all participants, and it will be put across social media also in the next week or so. There will be opportunity, and there is opportunity for you to ask questions through the chat box on the left-hand side of your screen. We will be collecting these, and we will be answering them if they're pertinent as we go through, but there will be a question and answer session at the end where we will hope to cover off most of the things that you are asking. Hopefully we've answered most of your question within the presentation, so but there is opportunity, so please ask your questions. If we could have the next slide, please, Kerry. What we're going to do this evening is an introduction to care and support, the things that you need to consider, what is available to you, what is an unregulated service versus a regulated service, what the Care Commission is and how it inspects and what the inspection criteria is. That will be presented by myself, Elaine Murray. I am the Community Ambassador at the Good Care Group. We will then have the tale of two case studies, legal planning for power of attorney, who can make decisions, Mental Capacity Act, what the court protection is and what the court of protection does, and what a guardianship is, and that will be delivered by Gail, and it will be delivered by Martin as the dynamic duo. So without further ado, we'll go to the first slide. If people have just joined us, and they are joining all of the time, just to let you know, you are muted. We cannot see you. This is being recorded and it will be sent out to you. So I'd like to start now. If I will turn off my camera, I think we need to do that, Kerry, am I correct? So that we can make sure that you see a full view of the presentations. So we're going to turn off our cameras, but you will hear our voices and you will see us at the end on the camera when we do the question and answer. Okay.
Thank you, Elaine.
No problem. Okay, there we go. In the UK, there are approximately 10 million people who are over age 65, which is 1 in 6 of us. So it's possible that the challenge of helping ourselves, our parents, and other close relatives to make decisions about support, care, or legal matters in later life is likely to come to many of us. When introducing care to a family member or a friend, it's critical that they feel in control and they feel reassured that they're able to maintain their independence and their own choices. Even if they lose the cognitive ability to make decisions, there is a way that they can ensure that the person making decisions for them is the person that they want. It's very difficult for a person to accept help when they've always led an independent life and feel that they're coping well. I know that it would be difficult for myself. So if we look at the available care options, excuse me, you can start with companionship. We all have companions, and it's very important for later life that we do have somebody we can rely on and we can trust. So where somebody is showing the signs of struggling, with the challenges associated with everyday living, support can initially be introduced through support interventions in the form of a family member, a companion, a personal assistant, possibly visiting for a few hours a week to help to make sure the shopping's done and to make sure things are in order for everybody and they have the things that they need. I think most of us do that, and I think that we know how valuable a good companion is, whether it be family or a friend. If a little more is needed, then hourly care providers or domiciliary care providers, as they're known, can deliver the support gap between living independently and needing more help. They can also support with personal care needs at set times of the day. And this support can enable someone to stay at home and families, of course, to continue their busy lives. If it's thought that more help is required over a 24-hour period, you can look at live-in care providers. They can enable people to stay at home with the support they need for everyday tasks, personal care, holistic and complex care. And holistic needs, I mean, all of the needs that we have that nurture our spirit, the things that pertain to us. Carers can manage changing needs, working with healthcare professionals to keep a person safe and well 24 hours a day. A consistent care team can build the trust and companionship that people need. And this type of support can enable a couple to stay together in their own home, or a person with memory loss to stay in familiar surroundings in the community they know with familiar faces around them. And that can serve to lessen the anxiety of memory loss. Residential care providers, for those who enjoy group living, assisted living in a residential care home might be the right option for them. For some people, this type of living introduces a new phase in their lives and it enables them to make new friends or be part of a structured environment. Take time to carefully consider this option, the changes to familiar lifestyles and the transition required to avoid anxiety. If we now look at, those are the options that are out there for different kinds of care. One will be right for you or your loved one, but it's about understanding what you will get, what do you need. So if we look at the next slide, please, Kerry. I just wanted to explain to you the difference between a regulated and an unregulated care service. When considering hourly and residential or living care, you should take time to discuss what you expect from the provider. Make sure you understand their contract with you and what that contract will deliver. Regulated providers are registered with the Care Quality Commission, and I'll explain a bit more about that in the next slide. They will offer an accountable service. You can search and read inspection reports for regulated providers before you're choosing the provider that you think will suit you best or your loved one. Carers will be supervised and will be supported because that's what a regulated care service delivers. Not all care providers are registered with the Care Quality Commission, and not all care providers train and supervise their carers. You may have to pay the carer directly as an employee, and carers may not have the support and advice of a backup service that a regulated provider delivers. So the important thing to consider, excuse me, make sure you understand what your chosen provider can and will deliver and ensure it matches with your expectations, and that you know exactly what your part will play in choosing either a regulated or an unregulated service. If we could go to the next slide, please, Kerry. Thank you. So the Care Quality Commission for regulated providers inspects services under a CLOE, or key lines of inquiry. Those key lines of inquiry are, as it says, they will look at this inspection criteria will look right across a regulated provider. It will interrogate their documentation. It will talk to the clients that they look after, and they will ensure from that, is the service safe? Is the service effective? Is the service caring? Is it responsive, and is it well led? An avoidable harm. Are they effective? Means, are they delivering what you need, you personally need? Does it have a personalized care plan that has been brought together with your input, or with your advocate or your family's input with your permission? Are they caring? I think we understand what caring is, but caring is different things to many people. Do they care about how you feel, what you have to say, and what your points of view are? Are they responsive? People's needs can change all of the time. People can have concerns. They can be worried about something. Being a responsive service means you are listening, means that you are acting. So if somebody's care needs change, are they responsive to this, in that they are looking at what else you may need? Do you need equipment? Are you happy with that? Are they responsive to your thoughts and feelings? Do they have either a complaints procedure to make sure that your views are listened to? Do they have an annual survey that asks you, how are we for you? How are we delivering? And that is kind of the gist of being responsive. Are they well led? Well led means, excuse me, do they have a management structure and policies and procedures in place that will protect you, that will take care of you, and that you can understand what that service delivers? So have they got consistent carers? Do you have the same carers all the time, or do you just don't know where you sit? Is the management structure there and in place, and have they been there for a while? That will be inspected as a well-led service. So if we could go to the next slide, please. So after they've looked at the key lines of inquiry, they will give providers a rating. Now, the ratings under each key line of inquiry, the responsive, the caring, the well-led, the effective, and the safe, will be given one of those symbols. Now, each one of those symbols goes to each key line of inquiry. Providers, an overall good means the provider is performing well. 2 ratings of outstanding, which is the star on the top, can achieve an overall rating of outstanding as long as the other key lines of inquiry are good. 2% of all providers in the UK achieve outstanding in all 5 of the key lines of inquiry. Some providers may find that some inspections throw up that in some key lines of inquiry, the inspection requires improvement. So if this happens, and I think we have that on the next slide, do we or do we not? Oh, no, we don't. Sorry, we didn't put that one in. So what will happen if somebody has an inadequate rating on several key lines of inquiry, or even one? There will be an action plan in place. This will be monitored, and the inspections will take place more often until those that plan of action has been updated and the service is deemed to be safe. Requires improvement. You can have 4 good ratings and it requires improvement. It doesn't mean to say you're not overall good, because it may be something like there was an issue, there is a plan in place, and that improvement can be met, but they will not change the inspection symbols for each key line of inquiry until they are satisfied, and possibly not until the next inspection. You can look for these inspection reports for any provider you choose that is regulated by the Care Quality Commission. You can go onto their website, you can put in the name or the postcode of that provider or any providers in an area, and it will show you the inspection reports and what their ratings are. This may well help you to choose the right provider for you. Planning for care is a daunting prospect for most and many, for most actually, and many people only address care planning in a crisis. It's important that we know what's available, what suits us, and how to go about helping yourself or others to achieve their wishes, and especially when somebody is experiencing difficulties with memory loss. Planning now will avoid crisis later, and people that you don't know making decisions on your behalf. As an example, and as a segue into Gail and Martin's presentation, if we take Kate Garraway, for example, her husband is experiencing awful battle with the effects of COVID, which he's had since March. And recently on the news, Kate told people that she was experiencing difficulties as most financial and everyday things were in her husband's name. She doesn't have a power of attorney, and she was finding difficulties with people speaking to her. So it just goes to show you that two middle-aged people with full cognitivity, when somebody loses capacity overnight through an unfortunate event, it's very difficult for the person that is trying to cope with things. So without further ado, I'd like to hand over to Martin and to Gail to offer advice and guidance put together through two case studies to explain the importance of ensuring that decisions we make are our own decisions and how they can do that. So without further ado, over to you, Martin and Gail. Thank you.
Thanks, Elaine. Can you all
Hello.
hear her? Yes.
Yes, I can hear you. I think we've
Yeah, we can hear you. Thank you so much.
Unmute ourselves.
Okay.
So I'm going to kick off, and thank you for joining us on this evening. And I'm just going to pick up that lovely word that would come through from earlier. It's the word planning. And we, as solicitors, especially they're quite a big, busy private client department that we have at Warner's. We see two types of clients: those who plan and those who don't plan. And I think that a lot of people fall into those categories: the planners and the non-planners. What we like to do is get our clients to plan and plan ahead and avoid trouble. That's good advice, and that's what lawyers do. We're also good at picking up the pieces at the other end for those who don't plan. We'd rather not do that, but we can do that, and I think we're unusual in being able to provide a service at both ends. And I think seeing the things that can go wrong helps us also to provide a better service at the planning stage. And so we've got two sort of case studies that we've tried to make this session relatively informal and personalized it. And I'm going to start off by talking about Patricia Perfect, who is, I believe, one of Gail's clients. Gail tends to deal with the planning, and she's very good at planning and explaining things very carefully and sensitively and getting people's affairs in order before anything goes terribly wrong. So this is one of Gail's clients, Patricia. She's a widow. She's got to be 80, but she's still quite fit and healthy. She has a bit of help in the house. Her husband died a few years ago. Of course, meticulous. He left a will. He gave her a life interest because he wanted to make sure that the children and the grandchildren would definitely benefit. So everything in apple pie order. So he knew exactly where it was going to go. And she's got her own will up to date, which is, hasn't changed very much, but she wants to make sure that her children will benefit and the grandchildren will benefit because they're getting a bit older too, and they'll need some help when the time comes. She's also very sensibly, she's made her lasting powers of attorney in favour of her son and daughter. Fortunately, they get on quite well. They're quite sensible. they live quite locally, and she's also made 2 powers of attorney, one for property and finance, and the other for health and welfare. She's also made an advance directive as to how she'd like to be looked after in the event of being critically ill. She's a little bit worried about her health as well, and she's also signed the DNA form as just in case she had to be resuscitated in an emergency. So if I can turn onto the next page, and then I think Gail will talk about one of my cases.
This is really where you need to call in someone like Martin, really calling in the cavalry to help for somebody such as Doris Doolittle, also a widow, aged 80. Her husband died many years ago. She has actually been cohabiting with Delicious Don for 10 years. She has 2 adult children, Diana and Dave, who are not keen on Don. Now, for the first thing, I thought I would raise with you the matter of next of kin. There is no legal definition in English law of what is a next of kin. There is, funny enough, in American law, but not in English law. Diana, as with a lot of middle-aged girls or ladies, they're seen to be rather bossy by their mums. Diana is bossy lady, desperately trying to get her mum organised, but not doing terribly well. Brother Dave works in Dubai and doesn't really care anyway. So Doris has always said, this is where the difficulty comes in, that she really wants Don to make decisions for her. So she has a will, she made it 20 years ago, leaving everything to her children, but taking no account of Don. She doesn't have any LPAs or other legal documentation in place, as she has always thought solicitors a waste of money. Not sure whether anybody's familiar with that kind of thing. Next slide, please, would be helpful. So I'm going to hand back to Martin as to why you should bother about LPAs.
Yes, well, Doris has been managing, well, she has managed for quite a long time. She's being a very sort of independent, sort of minded person. She's been fine, doesn't want to spend money on lawyers, and she's got away with it until about now. She has now got a diagnosis of dementia. She's had an accident, she's been in hospital, and she's struggling with help. And old Don, Dodgy Don, or Delicious Don, has been actually, like he's probably pulled his weight. He's actually proved he's been quite helpful, but he's struggling as well to look after her. But he has no legal standing to make decisions or to speak for her, especially as she's getting a bit forgetful and confused. So I suppose that's what happens if you don't plan ahead. Unfortunately, the law, the systems we have do provide quite a good framework for people to cover that situation. And so the Mental Capacity Act is there for people who may lack capacity, and so they can plan ahead and make decisions that empower them, so that they point the people that they want to make decisions for them when they can't make those decisions. So they have the right people in place with the right guidance and with the information that they'll need to make the right decisions for them. The legislation is also that in the Mental Capacity Act, and there's a very detailed code of practice which explains how it should be implemented in practice. It also allows people to make powers of attorney, so that you create the legal structure, appointing your attorney to make those decisions for you, and you can have powers of attorney for property and financial affairs, so to deal with your property, bank accounts, investments. You can specify whether they start immediately or at a time when you lose capacity, because sometimes there's a sort of grey area where you're getting a little bit forgetful. You might be a little bit frail. You just need help doing things. So you haven't lost capacity, but you need help, and then your attorney may need to step in and do things for you. You can also make a health and welfare power of attorney, but obviously that only comes into operation when you have actually lost capacity to make the health and welfare decision in issue. And I suppose the other idea is to keep people going for as long as possible. we're all living longer, our lives become more complicated, and that's what lasting powers of attorney are for. I think Gail will tell us a little bit more about the advice she gave to Patricia, and why Patricia's life is actually much more straightforward than it could have been.
I'm sorry, this looks a terribly boring slide, doesn't it? But I'll get through it as quickly as I can. It really is the mechanics of how a lasting power of attorney will work. The donor is the person, so this would be Patricia in my client's case. Patricia had to have mental capacity when she gave me instructions to draw up a lasting powers of attorney for her. She had to sign the document first of all. She had to have a certificate provider, which can be somebody who's known the donor for years or more, but I was able to sign in my capacity as a solicitor. My professional capacity, she could have taken it along to her GP, and the GP could sign. I'm not sure whether GPs would charge. I'm not too sure about that. And then after that, the attorneys, so Patricia's children, they had to sign in strict order. So Patricia, then me, the certificate provider, and then her children. And everything has to be dated in the correct order. Otherwise, the document gets thrown back at us by the Office of the Public Guardian. Word of warning, if you're thinking or you have a family member who's thinking of making a lasting power of attorney, it is taking months. In fact, it always has taken months, but even more months at the moment to register these documents with the Office of the Public Guardian. They cannot be used until they are registered. There's a registration fee of £82 per document, but this fee is means tested. So if someone's on pension credit, it is possible to get the fee reduced. You can apply for to make these powers of attorney online and avoid solicitors' fees altogether, but you will get no help as far as signing is concerned, nor advice on special instructions and guidance that can be so important as to how you might want your attorneys to act. So Patricia had some savings. She wanted some instructions included in her power of attorney for property and finance to allow her children to carry on making sure that her investments were looked after properly, and she also wanted to make sure that they would have access to confidential documents, so she put that in the instructions, allowing her attorneys to have access to confidential documents, including her medical records. So the problem with poor old Doris, on the other hand, this is really going to be repeating into the next slide. Doris, who wasn't so organised, nobody could access Doris's bank account. She had an ISA and an NSI account. Nobody could access that, and the DWP would not talk to Don, Diana, or Dave about Doris's state pension. Patricia, on the other hand, had everything lined up and organised, and things were much more straightforward for her. So the next, oh, sorry, that was such a boring slide, but I think the next one is, I think that's Martin's going to take over the next slide. Yeah, thank you.
Yeah, thank you for that. That sort of moves on neatly. I think I just mentioned one of the great benefits of the powers of attorney is that you put in place the chosen people you want to make decisions. But it's not just a case of letting them, you can just give them free rein to do what they want, but you can also give them a lot of guidance as to how they should do things and in what circumstances. And you can expand it to talk about people that they should consult, so you can involve grandchildren, other relatives, carers. So there are people that you want to be involved in the decision-making process. So it doesn't mean that other people are excluded. Meanwhile, poor old Doris, her affairs are getting more and more complicated. Her capacity is diminished. She can't actually get to the bank account and make decisions. We need to get hold of her money to pay for care. No one's talking to Don or listening to him because he has no status, and the children don't like him, and it's all a bit of a mess. He's really struggling. They can't get. They need to pay for care to bring that in. It's difficult. Also, there's a big dilemma for Don because if Doris does move into care, and I think the daughter's quite keen on mum going into a lovely care home, but then the house will need to be sold to pay for the care. Don will be homeless, and there's a bit of an argument about to start off there as to whether mother moves or not. And is Don really looking after mum and worried about her welfare, or is he just thinking, I need somewhere to live? And Of course, they should have gone to Gail a little bit earlier. You know, Patricia and Doris, they have chatted about this, and Patricia has told Rebecca, he said, you really must go and see Gail, this lovely solicitor at Warner's, and but she wouldn't do it. It's too late to make lasting powers of attorney. If we move on to the next slide, this is what is likely to happen to poor old Doris. Someone has to go to the Court of Protection to have the court appoint a deputy to make decisions for her. It's needless to say, it's quite a long, complicated process. The court it's an impersonal but impartial organisation in London. They don't know anything about the case, but, and they're being asked to make a really major decision on behalf of Doris. It's taking away her autonomy and imposing someone else on her to make decisions for her. So it requires a lot of evidence to make that the case. There's some evidence of the lack of capacity, which needs to be provided by someone who is qualified. At the moment, it's really difficult to get capacity assessments because doctors won't go out to see clients. I mean, it was quite difficult before COVID because a lot of GPs didn't want to get involved in difficult capacity assessments. If you could get a doctor to go out and see a patient, often you'd have to get a specialist to do it. I mean, it's much more difficult now because visits are more difficult. When you can get it done, it takes a long time to do it. And then the court process is also slow. It's even slower now than it was before. So it can take up to 6 months to get your deputy appointed. Someone needs to put all this evidence together, make the application. The sort of close relatives would need to be notified. So in this case, we assume that Doris's daughter will reluctantly, unfortunately, she's the one who lives nearby and responsibility falls on her. She's made the application. She has to notify her brother and Don. Brother's not very happy about this because he's been a little bit been in the background a bit and not that interested, but he doesn't really think his sister's up to it. He really doesn't quite trust her with money and doing anything growing up like being a deputy for mother. And Don has also objected because he doesn't quite trust her and he thinks she's going to sell the house and force her out. So it could be quite a complicated application. And we don't assume that the court will allow the deputy to sell the property anyway, because that's a big decision that has to be taken, and it may require evidence as to why it's necessary. Does Doris have a view about where it's a decision that needs to be considered on its own terms? So there's quite a long and difficult process to go through. It's quite costly, and I mean, hopefully, in most cases, eventually you get the right result because there is a deputy who is appointed, whether it's a family member. It might, in Doris's case, end up with a professional deputy because if the family and Don can't agree who does it, the court will usually refer it to an independent deputy who will be a solicitor, and there is a panel of deputies who take on these cases as a last resort. So whoever is then the deputy does have to provide detailed accounts. So every single item of expenditure is accounted for. Where there's a professional deputy, any costs are checked and assessed by the costs office. There's also an indemnity bond for all deputies, so that if there is a fraud committed by the deputy, there is a basic insurance policy that can be called upon to provide an instant payment for the estate to look after the essential care needs while the matter is being investigated. So there are some sort of checks and balances for those who fall under the Court of Protection, but it is quite a slow and costly process to get there. So meanwhile, I'll hand back to Gail to talk about how Patricia's getting on.
So thank you very much, Martin. It all sounds pretty grim having to apply for a deputyship order. So as Pat is living in her perfect world, Peter and Penny get along fine. It's not a problem. So when their mum was diagnosed with dementia, and the beginnings, they realised things were going quite wrong. When she paid the window cleaner £200 instead of 20, they knew that they would have to start running their mum's finances. So the attorneys call the solicitors and ask for certified copies of Pat's registered lasting powers of attorney to be sent to Penny. As she's nearby, she's going to register and run the finances along with her brother. So she and Pete go along to Pat's bank with her up-to-date ID, and they are then recorded as attorneys for Pat, and they'll receive new checkbooks, bank cards, and can register for online access. But this does take, just a word of warning, this does take about a month to 6 weeks, and it doesn't always go according to plan with some of the banks. So for all the good planning, it can be a bit of a painful process, as perhaps some of you already know, trying to deal with the banks at the moment can be quite tricky. But anyway, they're on course to get things sorted out for their mum, make sure she's okay. Could I please have the next slide? So poor old Pat's going downhill fast. She's carrying on with care at home. Someone is now living in with her, and the care agency, or the managers at the care agency, are reassured that there is a health and welfare LPA in place. Pat chose to give her attorneys permission to refuse or accept life-sustaining treatment if things were looking particularly bleak, and this part of the LPA is legally binding. And Pete and Penny know that she doesn't want to be on life support on a long-term basis, and she has set out her wishes in her advance statement, which is actually not legally binding, but it just helps Penny and Pete know what their mum wants to do when things get very difficult towards the end. So we're nearly there. Thank you for staying with us. I think we're on to our last slide, and I'm going to hand back to Martin. And thank you for staying with us. Martin,
yeah, thank you. Yes, no, thank you very much for staying in there. I don't think we've lost any attendees yet, because we're waiting for the last instalment, and maybe people want to know what happened to Doris. And after a great deal of argument between the family and Don, I'd like to think that eventually the court was able to assist. They appointed an independent professional deputy. Social services were also involved and came in to help with her care on a temporary measure, bringing in a care agency from outside. And there's also yes, and so the separate sort of decision was made about where Doris wanted to live, and I think then she was done very carefully, that she was seen by herself, and she made it very clear she wanted to stay in her own home, and that was very important to her. So the deputy made an urgent application to the court for an interim order to release some funds. Elaine and the Good Care group came in and provided the limited live-in care package, and I think eventually the children were satisfied that Don really wasn't going to get his hands on all the money, and the deputy would take care of the finances. Mum would stay there, and Don would have they agreed to have an allowance to help look after him, because there's just enough money with all the benefits that they could get, and her pension and some savings, that they could manage that. So that one eventually had a reasonably happy ending. The only other thing that they were going to have to do was sort out her will, because she'd lost the ability to make a will, that the court of protection could assist with that, with an application for statutory will, and that would that could ensure that the children would be the beneficiaries, but also Don's interests could be protected, so that he would have, I think they agreed eventually that he would have a right of occupation in the property for a period, and then he'd have a small bequest. So that one worked, that one quite well. So just to finish off, we've got some sort of the tales of the unexpected and the things that can go wrong. Just mention that most things do go well. Most attorneys and deputies do behave properly and do exactly what they should do. But there are always those cases that do go very badly wrong, and I suppose the whole point of the framework that there is for powers of attorney, the public guardian, and the court, it's to avoid getting into those situations. And there have been some quite spectacular cases reported. The Gladys Meat case was one of the most famous ones that had a lot of publicity in the Daily Mail and other newspapers, where there were cousins who became deputies for their elderly aunt, and they got through about 200,000 or 300,000 in expenses. And they made themselves gifts. They bought themselves cars on the pretext that they had to go and visit their aunt. They bought themselves presents because they thought that she'd want them to have those presents, new computers, and very large amounts of money as well. And then there's another case that came up before the court just not long after that, where a son had been acting as deputy. This is how it got picked up, because he was charging rather large amounts of money for every time he visited his mother. Public guardian does investigate allegations, and so the number of allegations does increase. I suppose the amounts aren't huge compared to the number of people involved. Just under 3,000 allegations, but there are nearly 4,000 powers of attorney and deputyships in place. So it is a small number. I expect there are a lot more that go undetected, because the power of attorney framework is unregulated. Occasionally things do get picked up when they go wrong because there are whistleblowers or people complain, but until something is picked up, it does go under the radar. And it's also, it is quite easy to so that's why it's so important to pick the right attorney. They are people you trust, and if things do go wrong, they can be quite spectacular, as in the Gladys Meat case. And often they go ahead without powers of attorney. I think my saddest case was that of a supposedly good neighbour who befriended an old lady who had dementia. She thought that she was in love with him and he was going to marry her, despite the fact that he would go and visit her with his wife. They opened a joint account together with about £5,000 because he was going to help pay some expenses, and did some odd jobs around the house. And she said, well, yes, you can use my bank account, and that's for you to spend. And over about a year, he managed to sort of tip about £500,000 out of her bank accounts, just using online transfers into that account, and spent about £300,000 on gambling.
Oh.
Bought himself a new car, new holiday, presents, and then eventually he did persuade her to change her to a will, which he left everything to her, and almost got away with it until I think then she ended up in hospital, and almost he tried too hard to be her good friend, and I think he was a little bit overly attentive to her, and one of the nurses in the hospital got suspicious and contacted social services, and they referred it to safeguarding, and then they looked into it and found some very large amounts of money that had been taken away. So that's one of those sad things that do go wrong, and unfortunately our cases that hasn't happened, but it's a little
Thank you.
warning of what can go wrong if you don't plan ahead.
Fantastic. Is there a next slide?
No, I think that's it. Now we have got
Well, that's
time.
absolutely fantastic. Yeah.
But can I just say something, that Martin is the expert, and as far as court of protection work is concerned, and acting as a deputy, he knows exactly how it all works, and we're extremely lucky to have him. So thanks.
Absolutely. Yeah, he well known and acknowledged and published expert of the court of protection.
He writes the books.
He
We
does
just
indeed.
read them. Yes.
Thank you. And Gail, expert in your field as well, and as deputyship, thank you so very much. I think the important thing for us all to hear from this presentation is plan, plan, plan. Those are the 3 magic words. If you gather your toolkit and just understand a bit about the implications of not having a toolkit, not knowing these things, but when you do need them, if you understand now, you will have those tools at your fingertips. Planning for care, understanding what you are buying, understanding the provider and what they will do for you, understanding that when somebody loses the capacity to make decisions for themselves, there is a legal framework to go through the Court of Protection under the Mental Capacity Act. But if you plan well and have a power of attorney in place, you won't be Doris Doolittle or Disastrous Don. It really is fundamentally important. We can lose capacity overnight if we have a catastrophic injury or illness. We don't have to be in our later lives, but if cognitive ability or memory loss does start to happen, it's important to get these things and understand these things and get them in place before capacity is lost, so that the decisions that you make are the decisions that you want to have happen for you, and that the person making those decisions for you is the person that you want those decisions, you want to make those decisions for you, because they know you and understand you. So if we could have the next slide, please, Kerry. Oh, there you go. And the next one. Is that the one? Okay, that's it. It leaves me to say thank you so much to our professional experts, Martin, Terrell and Gail Hall from Warner Solicitors. I will leave you on a note. If you do what you always did, you will get what you always got. So get your ducks in a row and understand what's out there for you, what can help you, and how to avoid crisis. Thank you so very much, everybody, for coming.
Thanks, Elaine.
Thank you very much.
Very kind of you. All right. See you again soon.
See you soon. Thank you so much. Good night, everybody.
Bye. Good night. Bye.